Welcome to the False Claims Act Insider, presented by Price Benowitz. With more than 15 years of experience as an attorney focusing on qui tam law, Tony Munter explores the risks and heroism involved in being a whistleblower alongside distinguished attorneys.
Appreciate your coming on. It's fun to have lawyers come on to talk about stuff like this, because frankly, there are not that many people who have been doing this as long as you have been doing, even though at one point I understand you were like the youngest graduate of Georgia Law School or something. You've been doing this for more than a decade, and so you must be doing something right. That's a long time to be hanging in as a False Claims Act lawyer. You're either really able to do it by that point, or you're likely onto something else, is my general experience with this stuff. So it's a thrill. What is your general advice in dealing with bankruptcy? Were you dealing with plaintiff bankruptcy or defendant bankruptcy more when you're thinking about that?
So most of my experience is with relator bankruptcy, but I've definitely had instances where the defendant is bankrupt as well. And you just never know. I mean, we bring smaller cases that a lot of firms are just not interested in. So we go in kind of knowing a lot of the time this is going to be ability to pay, and hope doesn't end up in bankruptcy. But as you've seen recently, even the large pharmaceutical companies on the opioid settlements, declared bankruptcy. So you just never know. From the relator side, my number one piece of advice is find out day one whether your client has ever filed for bankruptcy, and if there's any possibility they will file for bankruptcy. I have now put it into my engagement materials, and I make them sign specially that they've addressed this question, because what a lot of people don't realize is that a bankruptcy that is closed before they ever come in your door could still bar your False Claims Act case.
That's right.
So, it's good to know. And even though it's there, sometimes, people say no, and then they say, oh, I forgot about my bankruptcy. And it's just a lot of extra work. So you can, if you know about it on the front end, number one, it certainly, might change your decision on whether to take representation. But number two, you can go to the bankruptcy court. Essentially, the process is that we go to if there's already a case existing, we have to go to our court, get a partial lift for the bankruptcy court and the trustee. And then we go to the bankruptcy court and the trustee, and we advise them of this False Claims Act case that is not likely to resolve before their bankruptcy is over. And then we have to be appointed counsel. We have to file a petition under seal so that it's on the bankruptcy court record. And then, of course, the creditors start wanting to know what it is. And at that point, you need the trustee to kind of say, hey, everybody, trust me, this is it is in your benefit not to know about this, because you have to not breach the seal, but you also have to have it on the record, or you can get judicially stopped from pursuing it later on. So.
Yeah, it's a real problem. I tend to try and lean on bankruptcy counsel to do the actual, as I'm sure you do, the work with the bankruptcy court, and it depends obviously which court you're in, what their procedures are, which, and I try not to practice bankruptcy law, but I certainly know enough to know, and it's a great idea to put in the engagement letter, by the way, to have them disclose that to you. That's very smart. I'm gonna think about that now, because nobody wants to wake up 10 years later and find out that their big judgment is being stopped because you forgot to tell the bankruptcy court about it. So you said you do smaller cases. That's kind of interesting to me. I guess how are you able to do that? Almost everybody is whale hunting in this business. Why are you looking at smaller cases, and has it worked for you? I mean, I guess that's the real issue.
Yeah, I mean, this is our business model, and you're right. It is, everyone's out there. One of the earliest pieces of advice I got from, in my opinion, the most successful qui tam lawyer was, don't take a case worth less than $10 million. And I thought, well, if I had that many cases worth $10 million walking through my door, that'd be one thing. But, I have to put food on the table, and I have to get, as a younger lawyer, like I said, I've been doing this since 2008. but we opened our firm in 2015. And, there's just, there's plenty to go around, but obviously there's also still a lot of competition. And so, sometimes you've got to look at the smaller cases. And the reason we can do that, where a lot of firms can't, where you probably can't, is that this is all we do, and we're a small firm. We're not a section of a larger practice that has personal injury and, whatever other things they're doing, asking, Tony, what have you brought in lately? Right? Where are your cases? What are we paying for? So, we have the opportunities to go out. I actually did the math for another reason earlier. Probably about a third of our settlements have been 6 figures.
Okay.
And about half of the cases that we brought that were 6 figures were intervened and settled. So, yeah, so there's a stigma against them. There's people who say, well, the government doesn't. That's just not true. There's definitely offices who, like you said, the U.S. attorney's offices that have big cases don't have time and resources for these. But fraud is fraud. And if you've got good facts and you've got an office willing to work on these smaller cases, there's no reason I can't put together one of these cases for $50,000 in fees, and you settle it for $350,000. And, I've almost covered my, overhead for the year, because we are just a couple lawyers, a paralegal. We have a couple layers of counsel. So, you add a couple of those up over the year, and everything else is gravy, and then you can focus your resources on the larger cases. But
what kind of cases tend to be, I would assume that if you're going to go for a lower dollar case, that it has to be pretty nailed down in terms of liability, that you're not going to, the sort of analysis you would take is the higher the damages, maybe you make a little bit more of a guess on liability. But what kind of cases are you seeing that are smaller dollar cases that are worth, in your view, doing?
That's exactly right. It's a sliding scale. The worse the facts are, as if your damages are high enough, you might still, take a flyer. But most of ours are going to be small medical practices, or pharmacies, things like that. So, it's great to bring a case against the hospital, but sometimes Dr. Jones down the street is, billing for procedures that he didn't do. And our nurse comes to us and they think, yeah, these are good facts. We have an insider. That makes up most of them is going to be your local medical practices.
Really? So it's, and obviously there you're going to have some patient harm that you figure that the U.S. attorney is going to be maybe a little bit more likely to go after it, even if the money isn't quite as big. They want to put, folks that are doing stuff bad out of business.
Yeah, exactly. And and they're usually, you'd be shocked how many times we hear things like, yeah, my doctor says I'm not doing enough fraud to get caught, right? They're egregious about it. They're out there saying things that, a larger, more experienced fraud committer wouldn't normally say. They just feel like they're invincible. They're never going to get caught. And that pisses off the AUSAs. It's, when I can bring them a case, I had a call yesterday on a case. It's likely low 6 figures.
Right.
And it was exactly that. The guy was bragging about it to his work staff. And that drives, certain AUSAs nuts, because, they want to go, even get these low hanging fruit, even when the damages are small. But another thing I've learned is that I'm just never right about damages anyway. You bring these cases that I have 2 great examples. I have a case where we have had insiders at a hospital who worked in the revenue cycle office, who ran this massive report to tell me there's about, $6 to $7 million worth of fraud. And by the time the government was done investigating, they said there was about $50,000.
Yes.
And we said, we couldn't have had a better relator. The guy had access to every piece of data you could want. Same thing, we had a case, we took even smaller cases when we started, because, you have to do that. We have a behavioral health case that, we thought, oh, this is a tough one. It's, these are often patient by patient file reviews. And we figured, yeah, there might be $1 million. You might get into $1 million. Right. And, it's fabricating of services and there was, just, they weren't doing anything. And the government came to us, it was 5 years later, and said, yeah, we're pursuing this different theory that is just going to take all of the claims. And now it's a $12 million case.
Whoa.
So,
I have to say that's never happened. I've never
right.
had damages go up.
Yeah. And they're just like, your claim is good, but it's a lot of work and it's very difficult. And there's going to be a lot of arguments. This other theory, it's kind of fringy for a False Claims Act theory. But we also know she doesn't have $12 million. So, it's going to be ability to pay at the end of the day anyway. But same thing, you've paid for your year of overhead, and then you can go, do some bigger cases. Yeah.
Yeah. That's a good thing. That's a really good thing. And I guess there's the satisfaction of having put a fraudster out of business, which, which is kind of why we do this. I mean, if we were just doing it for money, I think we'd probably be on the other side, to tell you the truth. I mean, it's
yeah. And this, frankly, one of my favorite things to talk about is the small cases we do. So I have AUSAs who thank me for them, who absolutely say, we understand you're not going to make a lot of, they apologize the whole time. And they say, this is not going to be a big case, but we're so thankful that you brought this to us. And we appreciate that you guys bring us these cases, which is the opposite of what you would expect, right?
Yeah, that really is the opposite. Is this any particular office, or is this all, your experience across the board?
I mean, we're careful, we're not going to file necessarily, a $500,000 case in like Chicago or New York City. But we do a lot of business here in Georgia, and we definitely, I think all 3 offices in Georgia do not mind, if the facts are good. Yeah, I've heard it. Yeah. I mean, Georgia is probably where I hear it most. Yeah. And Medicaid too. The Medicaid teams, I've had I had a frank conversation with an AUSA recently where I said, hey, I'm going to bring you this. It's not huge dollars. He says, what do I care? I get paid the same anyway. Right. I mean, to them, that's what they're there for. They don't get the headlines. They don't get a commission. So, I've had them apologize for the size of the settlements where they end up. I've had them say, you bring us really good cases and we really want to, you get a feeling that they're working harder for you on those and the bigger cases because you've developed these relationships. And where I've really found success is you learn so much that when the big case comes in, you're ready to roll and you know what to do and you know what to look for. My best example is we had a compound pharmacy case. I didn't know anything about compound pharmacies. I knew it was small and I thought this is an opportunity to learn the case and maybe make some money. And we ended up with a settlement that I think was like $300,000. A month later, someone else walks through the door with a compound case. It's the exact same stuff. I say, I've done it already. I can whip this up and no problem. It's a $350,000 case. A few months after that, that guy refers me another compound pharmacist that is a potential mid to high 7-figure case.
Yeah.
And we've already done the work. So it's, from there you just roll into it.
Yeah,
so.
You understand it a little bit. And every aspect of this stuff gets more and more esoteric, and that makes a lot of sense to me. I guess what I find interesting though as well is with the whales, with the big cases, it's not that easy to resolve them, even when they're successful, even when they're great. It usually takes a long time, and I could see situations in which, an AUSA may be reluctant to spend the next 10 years of their life, which is usually what it might, not usually, but often what it may involve, to pursue some of these big cases. And maybe they like, actually bringing a case to fruition. I have a case right now. It's out of seal. It was under seal for 7 years, and it's like, it's just not. It's not on. You can't really build a practice with cases waiting around for 7 years, even for the government to make its decision. It's difficult.
I tend to agree. I think, especially certain offices, they prefer these cases, and you bring them a whale and they want the whale and they're asking for whales, and then, you know, it's the dog that caught the bumper, and like, oh gosh. And then, you know, 5, 6, 7 years go by. Like you said, people are in and out. They're not, it's exhausting. It's hard. And then they decline. And you're like, what have you been doing for 7 years that you would decline? No, I think we all like winning. We all like the feeling of a victory. And when you can bring them, and look, I'm not, like you said, I'm not bringing them a difficult, low dollar case. I'm bringing them, this doctor is billing for something he didn't do, right? I'm bringing them, you know, there's a kickback situation here. All you got to do is calculate your damages. And I think they love those. I think they love knowing that in a year and a half, 2 years, there's a possibility of closing that and getting, you know, a settlement.
Not that, I mean, just to be clear, Bracker Marcus isn't going to turn down your average $10 billion case.
No.
You would be happy to.
And I'll tell you one more thing is they're not hiring King and Spalding. They're not hiring, you know, Ropes and Gray. They're hiring, you know, this attorney who may or may not have ever done False Claims Act work, you know, who is not inclined to litigate this. They are out there looking for a settlement and, you know, to get out of trouble and keep their license.
Yeah. And it may or may not be a bet the farm case too. It may not be, you know, a lot of times when you bring these cases, you know, they feel like they have no choice but to litigate forever because, you know, it could be the, you know, plus, I don't know if you've experienced this, but with defense cases, it's really problematic. You can't ever really get those settled because they can get their attorney's fees paid while you're, you know, it's just it's a nightmare. But I mean, so you know, that's really quite an interesting business model. I like it very much, and I'm intrigued by it, I guess I would say. I guess you must have to have a base in a city like Atlanta, a relatively big city with a relatively robust, you know, economy that isn't, you know, like DC focused on, you know, the federal government so much, but like a, for lack of a better term, a normal place. That probably helps too, I would think. You know, here we're all, if you're in False Claims Act world or employment law world, everybody sort of is already geared towards dealing with the federal government. It's a little different. You know, we have normal business here too, but you know, not as much. I guess, for lack of a better way of putting it. What are you seeing mostly? You said compound pharmacies. Are you seeing any other kinds of new cases we should be on the lookout for? Is there an area of fraud we should all be sort of flagging as potential new areas of business, or is it still healthcare all the time, or any particular type of healthcare you're looking at, or what's come across your desk lately?
Yeah, I've probably spent most of my last year working on genetic testing and telehealth. I have, I think, basically 6 of those cases now around the country. They're all very similar schemes. If you look at, there's something called Operation Double Helix, which came out in late 2019 that essentially set out what the scheme is, and they started indicting a lot of people. So I don't know if I'm going to get any money out of any of these cases because a lot of my defendants are facing criminal indictments. But it's a really blatant scheme that pays a huge amount of money. Essentially it is, so I've got different parts of the scheme, but my marketers is where you start, are these people who are going out and essentially setting up tables at grocery stores or at healthcare fairs and getting people to come swab themselves for genetic testing. And they say, hey, we can do these cancer genetic tests, or there's something called pharmacogenomics, which is what medications are you on? We can check your genes to see how sensitive you are, how well they work for you, because different medications work differently on different people based on your genetics. The idea behind these tests is, you know, especially, so cancer is your big one, CGX. And the idea is if you have cancer or you have immediate family members with a history of cancer, it's a real specific niche. And I think it's mostly limited to breast cancer. We can look at your genes and see are you likely to have breast cancer again? Is this genetic? Is this, was this a non-genetic breast cancer? And it becomes part of your treatment. That's what it's intended to be. And it's very high paying. It's a high paying test. What it is not intended to be is, hey, I'm interested in finding out if I might ever have cancer. And that's really kind of what these marketers have turned it into. So they get these swabs. They then sell the swabs essentially to laboratories. The laboratories will give them some sort of kickback for the swabs because the labs are the ones who are really doing the billing. So sometimes they're independent marketers who are just looking for labs. Sometimes the labs bring in their own marketers. To begin, so you have medical necessity, you have a kickback. You cannot pay a 1099 contractor to go get swabs. You usually they have somebody has a physician who is getting paid to sign for these requisitions because you have to have a physician's order. So that's where telehealth comes in. And there's a lot of ton of indictments of, hey, basically someone pays me $50 to sign one of these. And I don't look at it. I don't ever talk to the patient, certainly not part of their care. And at the end, a lot of times the patients don't even get their results. So the whole thing was just a scam.
Just to think bill Medicare for the test.
Yeah. So we have cases where our clients are the labs, where the clients are the marketers. We have cases where the clients are the doctors. And we'll just see if any of them come to fruition. But that was my 2020 was working on these.
That's interesting because I want to say a year or two ago, I got into telehealth, and now I'm really not sure what's going to happen because as you probably know, the Stark law was a little bit reined in, I guess you would say, with respect to telehealth for obvious reasons for COVID. And, some of that's very legit. I mean, you want to expand telehealth services in a pandemic, but it's also going to create, I think endless amounts of potential for abuse because it's just, you got all these doctors all over the place. And, the way to make money in telehealth is to do volume business. And at some point, volume business in telehealth is, sort of asking for trouble, if you ask me. It's just, maybe not, but I think that's where we're headed. I think that's a big area of practice right now. I haven't seen much, in the traditional pharmaceutical and medical device areas of, big fraud. I haven't seen much, we haven't seen, for all the talk of whales, I haven't seen a real whale case get settled in quite a while. So that's going to be kind of interesting to see if that, if they surface again.
But we're litigating a whale, but we'll see how that
really?
resolves.
Is that a seal?
Yeah, it's we're in the Middle District of Florida. We're in the middle of discovery. It's a dialysis provider. Our case is based on lab testing. That when a patient goes into dialysis, I think weekly or biweekly, they're going to get blood drawn or serum drawn, and their levels are checked, and that's going to affect how they get treated, what kind of dialysis treatment they get. It's also really important for hepatitis C, which is easily spread around the dialysis center if a patient has that. So they all get sent back to this lab, and essentially our case is based on just the testing is not accurate. They're sending them from all over the country. There are a wide range of temperatures. They sit for a while before they ever get to them. And so there's, to us, it's a really vital part of the treatment. Our expert has explained that, if you're just wrong about some of these, it could be fatal. And so that's our case, is the claims that were based on those lab testing.
Wow. And you're litigating it, so it's out of seal and it's declined, or?
It is declined. Yeah. It's I don't know if it's technically declined. I think it's really more one of those. The court has ended our seal, and we have not reached a decision cases.
No.
So
those are always the trickiest position to be in with your client, I'm afraid.
Yeah.
But that must be taking up a fair amount of your time if you got to go back and forth between there. I mean, I guess you can do it by Zoom now, but
Yeah, there's no travel. There's no travel for depositions. It's all Zoom, and we have great co-counsel on that case that we brought in. Another aspect of our, just to kind of talk about our business model, is we're litigators. We're not trial attorneys. And we're certainly not prepared to spend millions of dollars, on a case like this. So, we are always willing to litigate good declined cases, but sometimes that means bringing in your, large firm trial team. And that's our standard practice.
Yeah, I'm doing that right now with a case, as I probably told you about. And it's important to know, I think, what you can do and what you can't do. And I haven't, there's probably 3 or 4, but there's not very many people that have like so much of a skill set that they can go from filing a False Claims Act case, even understanding a False Claims Act case sometimes is a whole issue, and through fully litigating it at trial. Because how many of these things go to trial anyway? I mean, it's like, so I think you're wise to handle it that way. I think that makes a lot of sense.
Yeah, it's good to focus on what you're good at, and not spread yourself too thin. And I worked for a firm where we had that whale, and we were basically financing it ourselves, and it's a different experience, right? 4 years of litigation where you're sinking tons and tons of money. At the end of the day, you've got to settle or you're in trouble, right? And that's just not good for the client. When the lawyer faces all that pressure to get it resolved, hell or high water, it's not, you don't want to go into trial that way. You want to go into trial feeling comfortable that whatever happens here happens. Now we can really do our best to try to maximize the judgment and not just try to get out of this.
I also have another aspect to it, and I agree with you, by the way, in terms of but what you said, but my other issue is, if it's a declined case and I've had the case for 5-6 years, chances are pretty good that I really like the client and that I really believe in the case, and that's fine and that's great. But it also may mean that I'm not objective about the realities of that case. Mm-hmm. And I have found it sobering and useful to have a policy that I have to sell it to another firm, in the sense that I know that firm is looking at it much more cold-eyed, much more objectively in terms of its chance of success than I can at that point. I mean, I think and I think that that's really important. There's costs, there's tying up your client for the next 3 to 5 years of their life. There's the potential for them being stigmatized as a whistleblower much more if they litigate it than if they don't. I just feel like, to me, it's if it's appropriate to have somebody else take a real hard look at it at that point. I mean, after all, you haven't been able to really talk to anyone else about it for 4 or 5 years. Mm-hmm. You believe your guy, and you think your guy's right, and whatever the department is telling you, it isn't convincing you that you're wrong. I feel like that's another sort of check on my judgment at that point.
Yeah, that makes a lot of sense. And we benefit from the fact that my partner Julie is the ultimate optimist, and I am the ultimate pessimist. So we're constantly balancing one another out, where I think, God, this is just not a good case. She's like, I don't know what you're talking about. You have good evidence. And then she thinks, oh, this is a great case. I say, no, I wouldn't take that one. So we definitely balance each other out in that sense.
How did you guys get into this? I mean, it's a weird area of law. Everybody's got a weird, I shouldn't say it's a weird area of law. It's not an area of law that they tell you about when you're going to law school. That's for sure. Mm-hmm. How did you get into False Claims Act work?
I totally randomly. I came out of law school in 2006. So it was right when the market was crashing. Everyone the year before me had jobs, but they were all starting to get fired. So there was not a whole lot of hope for me. I went and I clerked for a federal magistrate judge in Savannah, Georgia for about 8 months. Came out, still couldn't find the job that I wanted. Did just kind of a general practice with some guys from law school doing evictions and uncontested divorces, and then indigent defense. And then I just, probably 6 months after that, I saw a job listing on Career Builder that was right in basically where I grew up. And I knew going into law school, I wanted to litigate, I wanted to work at a smaller firm, and I wanted to stay in an area like Atlanta. And this met all three, and it was a Quitam law firm. So I worked there for 6 years. That's where I met Julie. Julie had gotten her start actually defending a False Claims Act case. She worked at an Atlanta firm called Rogers and Hardin, which is an extremely well-known firm down here. And she was a defense attorney on the life care case. And that went on for a number of years. And she said, yeah, this is interesting. So same kind of thing. She saw a listing for the same firm a couple of years earlier and said, yeah, I want to try the other side of this. So we got together working there, and then we broke off to start our own law firm.
That's really terrific. What a great story. I mean, I don't know anyone who does this that doesn't think it's the most interesting kind of law that you could ever do. I came to it relatively later, but you get obsessed by it, and I guess that's a good thing. And I'm really glad for you. I'm glad for Julie. I'm glad your firm's doing so well. And I really do thank you for your time. And I'll make sure we get the backlinks and all that stuff when this is the transcript. But thanks for your time. And I should tell you, I just joined a committee with TAF to do blogs and stuff. And so if you've got ideas for blogs or you wanted to post a blog, we'll be probably in contact with members if they want to blog on TAF as well as.
Okay, absolutely. Yeah, we try to blog fairly regularly. One of our counsels, Anna Dover, did one that we submitted to TAF, and TAF posted on COVID fraud, I think. So we're always looking for that. But yeah, absolutely. I mean, you're right though. I love what I do, and it's great because you go to parties and people ask, and they're like, oh, I'm a lawyer, and then they look at you slanty eye, and they're like, oh, I don't know that I like you. And then you tell them what you do, and their face lights up, and they're like, "Oh, whistleblowers, cool!
Yeah,
like, yeah. You're one of the good guys." I think, yeah.
I've had that happen, and it does make you feel better. I mean, it's a lot less like an ambulance chaser and more like not that there's anything wrong with that, but
absolutely.
Yeah. All right.
Well, anytime, Tony. I appreciate the invite.
All right, my pleasure. Say hi to Julie. Thanks for your time.
I will. Absolutely. You have a great day.
Thanks for tuning in to this episode of the False Claims Act Insider. Be sure to check back next week for more insights into the world of whistleblower and Quitam law with your host, Tony Munter. All episodes can be streamed on pricebenowitz.com along with your favorite streaming platforms.